The Department of Justice releasing its remaining documents from the Jeffrey Epstein investigation. Deputy Attorney General Todd Blanche saying the records will be posted throughout the day, including more than 2,000 videos, more than 180,000 images, some of the material so explicit you have to verify being an adult before you can actually access it.
Many of Epstein's survivors have been publicly pushing for years to have these documents come out, but it took a law passed with near unanimous support in Congress to finally bring these documents to light.
Victims of Mr. Epstein have gone through unspeakable pain, and there's nobody that should say anything differently. And I, to the extent that there's frustration, I understand where that comes from, just from what we know about Mr. Epstein. I hope that the work that
3.5 million pages, more than 2,000 videos, more than 180,000 images. Some of the material so explicit that you have to verify you are an adult before you can access it. The Justice Department just released what it is calling the remaining documents.
Sex trafficking case. We're now hearing from some Epstein survivors, though, who say their names appear unredacted throughout the documents, despite assurances directly from DOJ that no personally identifiable information about victims would be released.
To release them voluntarily and chose not to. And here is what happened on the day they were finally released.
Death. And one of those prosecutors writes, I'm going to read from this letter because it is what was new to the prosecutors at the time and what is new to us now, receiving these documents now in the public sphere from the Justice Department. The prosecutor, unnamed, an assistant U.S. attorney of the Southern District of New York, wrote on January 8th of 2020, the flight records we received yesterday reflect that Donald Trump traveled on Epstein's.
Survivors of Jeffrey Epstein's abuse, the women whose testimony put Ghislaine Maxwell in prison, the women for whom this entire document release was supposed to deliver some measure of accountability, started calling their lawyers. Because their names were in the documents, unredacted, exposed to the public. The very people the DOJ explicitly promised to protect, in writing before the release, had been identified by name in documents posted on the internet for anyone to see. The attorney who represents 11 of Epstein's accusers described it on CNN with a precision that deserves to be heard exactly as he said it. On one hand, it is a cover-up. On the other hand, it is incompetence, a perfect storm of trying to cover up what they do not want people to see while accidentally showing people what they should not see. Cover-up and incompetence, simultaneously, from the same Justice Department, in the same document release, on the same day. And buried in the press release announcing the release, almost as if they hoped no one would notice, the Justice Department included a warning that some of these 3.5 million pages contain what they described as false and sensationalist allegations about President Trump that were conveniently submitted to the FBI just before the 2020 election. They released 3.5 million pages. They warned that some of them are false. They did not identify which ones. They did not separate verified from unverified. They did not explain their methodology for redaction. They dumped a mountain of documents on the public with a small cautionary note stapled to the front and called it transparency. That is not transparency. That is what accountability looks like when the people responsible for delivering it do not actually want to deliver it. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video. Let's establish exactly what happened on the day these documents were released. Because the sequence of events tells you more about this administration's approach to accountability than any individual document in the release. The Justice Department had a deadline to release the Epstein files. They missed it by more than 6 weeks. That deadline was not a suggestion. It was established by a law passed by Congress with near unanimous bipartisan support. Both Republicans and Democrats voted for it. The public wanted it. Congress mandated it. And the Justice Department blew past the deadline by a month and a half. When they finally released the documents, survivors immediately began finding their names in unredacted form throughout the files. Not Jane Doe designations, not anonymized references, their actual names, driver's licenses with identifying information, personal details that the entire legal architecture of this case had been built around protecting. The attorney representing 11 of these women, Eric Fidali, described what he saw clearly. He heard that a driver's license showing a survivor's name had been included. He described it as incomprehensible how poor a job this has been. He filed emergency briefs with federal judges requesting the appointment of a special overseer to supervise the ongoing production and ensure it is being done in compliance with the law. Meanwhile, documents that had been posted were quietly removed. The CNN Justice Department correspondent reported that at least a couple of documents had been taken down after being posted publicly. No explanation offered, no announcement. Posted, then removed. The public's window to see them closed without warning or transparency. And the redactions themselves. The attorney flagged two specific justifications the DOJ used to withhold material: attorney-client privilege and ongoing investigations, both of which he identified as categories so broad and so difficult to verify that they essentially function as unlimited permission to withhold whatever the department wants to withhold with no accountability to anyone. You could say anything is an ongoing investigation and then withhold. His words, not an accusation. An observation about how the legal framework being invoked creates a structure with no oversight and no check. The congressman who authored the legislation forcing this release, Thomas Massie, a Republican from Kentucky, and Ro Khanna, a Democrat from California, went on CNN together and said that after reading the unredacted files in a secure government facility, they believe at least 6 powerful men are being actively protected through excessive redaction. At least 6. Including potentially someone who holds or held senior position in a foreign government. They cannot name them. The files are classified. But they felt morally compelled to tell the public that what they read and what the public is receiving are not the same document. Let's talk about Trump specifically, because the administration's handling of the Trump-related material in this release is one of the most extraordinary things the Justice Department has done in recent memory, and that is saying something given the competition. The DOJ included in its press release a warning that some of the documents contain, and this is a direct quote, false and sensationalist allegations about President Trump that were conveniently submitted to the FBI just before the 2020 elections. Parse that sentence carefully. The Justice Department is acknowledging that documents in this release contain allegations against the sitting president. It is characterizing those allegations as false. It is attributing a political motive to their submission, describing them as conveniently timed before the 2020 election. And it is doing all of this in a press release, not in a legal filing subject to evidentiary standards, not in a court proceeding where the characterization could be challenged, but in a public communications document issued by a department that serves the president being accused. The FBI did compile a list of sexual assault allegations involving President Trump in 2025. CNN's Justice Department correspondent confirmed it. The FBI compiled a list of all sexual assault allegations associated with the Epstein case that involve the President of the United States, some of them stretching back years and decades. The correspondent was careful to note that many of these are unverified, that some are second- and third-hand accounts, that the FBI records them and then works to verify them, and that many in this case appear not to have been verified. That careful, honest reporting is exactly the right approach. Record what exists. Be precise about what is verified and what is not. Do not inflate or minimize. What the Justice Department did is the opposite. It characterized allegations as false in a press release, attributed political motivation to their existence, and released 3.5 million pages without clearly identifying which material is verified and which is not. The public is left with a mountain of documents, a warning that some are lies and no way to tell which is which. That is not how you handle a document release designed to deliver accountability. That is how you handle a document release designed to create maximum confusion while protecting specific interests. Jeffrey Epstein and Trump were close friends for a period. Trump himself has acknowledged it and described the falling out they eventually had. Trump has consistently denied any knowledge of or involvement in Epstein's illegal activities. Those denials may be entirely true. The question of what the documents show about the nature of their friendship and what Trump knew or did not know is a legitimate question that the American public has a right to have answered through a transparent, credible, overseen process. What they got instead was 3.5 million pages, a warning that some of it is lies, no methodology for telling the difference, and a DOJ that missed its own deadline by 6 weeks and exposed the survivors it promised to protect. Let's talk about the question that the attorney Eric Fadali raised on CNN, because it is the question that sits underneath everything else in this story, and it has not been answered honestly. The Justice Department did not need a law to release these files. They had the authority to release them at any time. The Obama administration could have released them. The first Trump administration could have released them. The Biden administration could have released them. None of them did. It took Congress passing a law with near unanimous bipartisan support, meaning both parties in both chambers of a politically divided Congress agreed this needed to happen to force the release, and even then the deadline was missed by more than 6 weeks. Fadali's analysis was direct. Something was stopping the release. It was not the will of the public, which wanted the files released. It was not Congress, which passed a law requiring it. It was not the courts, which have been pushing for greater transparency. So what was it? His conclusion, stated carefully and based on the process he has watched as an attorney for Epstein survivors, is that this administration is the one who was blocking the release and appears to continue blocking it through the redaction choices being made now. That conclusion is not a conspiracy theory. It is a logical inference from the observable facts. When every other entity withstanding on this issue, the public, Congress, the courts, the survivors, wants the files fully released, and the Justice Department misses its deadline by 6 weeks and releases documents with survivors' names unredacted while withholding other material under broad, unverifiable privilege claims, the question of whose interests those redaction choices serve is entirely legitimate. The Deputy Attorney General Todd Bland said the White House had no purview, no control, no influence whatsoever on this review. Fadali said he has difficulty believing that, not because of speculation, but because of the observable pattern. An administration that could have released these files chose not to until forced by law. That choice protected someone. The question of who it protected is what the redactions are preventing the public from answering. Massey and Khanna read the unredacted files. They came out and said, powerful men are being protected. They did not have to do that. They could have read the files, left the secure room, and said nothing. They chose to go on CNN and tell the American public that what they were reading and what the public is receiving are not the same story. A conservative Republican from Kentucky and a progressive Democrat from California making the same statement after reading the same classified documents is not partisan noise. It is a signal. Let's be precise about what this document release actually tells us, because 4 things define what happened here and what it means going forward. Point number 1. The survivors were exposed on the day that was supposed to be about finally protecting them. Ghislaine Maxwell is in prison. Epstein is dead. The women who survived his abuse have spent years fighting for the documents that would complete the public record of what happened to them and who was involved. They were promised by the Justice Department that no personally identifiable information about victims would be released. Their names appeared in the documents anyway. One woman's driver's license was included. That failure is not a footnote to this story. It is the story. The entire justification for how these files were handled, the years of delays, the redactions, the missed deadlines, the attorney-client privilege claims, was ostensibly to protect the victims. And on the day the files were finally released, the victims were the ones who got hurt. Their lawyers are filing emergency briefs. Their names are on the internet. The protection they were promised was not delivered. Point number 2. The DOJ characterized specific allegations as false in a press release without identifying which allegations, without subjecting that characterization to any evidentiary standard, and without giving the public any way to verify the claim. This is not how a credible institution handles contested factual claims in sensitive legal matters. Courts exist precisely to make findings about what is true and what is false under evidentiary standards with adversarial process and judicial oversight. A press release is none of those things. It is a one-sided characterization by an institution serving the person being accused, issued without any mechanism for challenge or verification. The FBI compiled a list of allegations. Some may be unverified, some may be false, some may be credible. The public's interest is not served by a blanket characterization in a press release. It is served by a transparent, overseen process that applies consistent standards to the entire document set and makes those standards public. Point number 3. A bipartisan pair of congressmen who read the unredacted files said powerful men are being protected through excessive redaction and felt morally obligated to say so publicly, even though they could not name names. Massey and Khanna are not natural allies. They agree on almost nothing in the normal course of congressional business. They agreed on this. After reading the same classified documents in the same secure facility, they reached the same conclusion and made the same decision to go public with it, even knowing they could not provide the details that would make the alarm fully comprehensible to the public. When people with nothing to gain from the political fallout and everything to lose in terms of the classified access that requires them to stay quiet about what they read, choose to go on national television and tell the American people that the story they are receiving is incomplete, that is a signal that the incompleteness is significant. 6 or more powerful men. Excessive redactions. At least one potentially a senior figure in a foreign government. Point number 4. The Trump administration is the only entity in this entire saga that did not want these files released, and the release they finally delivered is incomplete, months late, and already identified as inadequate by the survivors it was supposed to serve. Congress wanted the files released. The public wanted the files released. The survivors wanted the files released. The courts have been pushing for greater transparency. The only entity consistently resistant to full disclosure has been the executive branch. Across administrations, but specifically and most recently this one which had both the authority and the mandate to release the files and missed its legally required deadline by more than 6 weeks. The attorney who represents 11 survivors reached a logical conclusion from those facts. Something was stopping the release. It was not Congress. It was not the courts. It was not the public. The logical conclusion is the administration. Whether that conclusion is fully correct or not, the observable facts that support it are not in dispute. So here is the bottom line. 3.5 million pages released, more than 2,000 videos, and 180,000 images. A deadline missed by more than 6 weeks. Survivors finding their names unredacted in documents that the DOJ promised would protect them. Driver's licenses with identifying information posted publicly. Emergency legal briefs being filed by survivors' attorneys requesting judicial oversight of the entire production process. The FBI compiled a list of sexual assault allegations involving President Trump. The DOJ warned in a press release that some of the documents contained false allegations about Trump while not identifying which ones or applying any verifiable standard to that characterization. Documents were posted and then quietly removed with no explanation. 2 congressmen, 1 Republican and 1 Democrat, read the unredacted files and came out and told the American public that at least 6 powerful men are being protected through excessive redaction. They felt morally obligated to say so. They did not have to. An attorney who represents 11 survivors called it a perfect storm of cover-up and incompetence. He said something was stopping the release. He said the logical conclusion is that this administration was the blocking force. He said there needs to be oversight because right now there is none. Jeffrey Epstein abused and trafficked vulnerable young women for decades. Some of the most powerful people in the world moved through his orbit during those years. Ghislaine Maxwell is in prison. Epstein is dead. The full accounting of who else knew, who else was involved, who else enabled what happened to those women is the question that 3.5 million pages were supposed to begin answering. Instead, the survivors have their names on the internet. The powerful men that Massey and Khanna identified remain behind redactions. The DOJ missed its deadline by 6 weeks and is characterizing specific allegations as false in press releases rather than in court proceedings. And the administration that had every opportunity to release these files voluntarily chose not to until Congress passed a law forcing it. The survivors went through unspeakable pain. The Deputy Attorney General acknowledged it in the statement that opened the release. Those were his words, unspeakable pain. And on the day those words were said publicly on camera, the department he leads exposed those same survivors by name in documents posted to the internet. That gap between what was promised and what was delivered is not a technical failure. It is a record, and the question of who benefits from that gap, from the redactions, from the delays, from the characterizations in press releases rather than courts, from the documents posted and then quietly removed, is the question that is still waiting for an honest answer. Stay with it. Because this story is not about documents. It is about whether the most powerful people in the world are subject to the same accountability as everyone else. And the answer that this release delivered is not yet yes,